Hello, everyone. This is Professor Elix of U.S. Government, Langston University. And today we will go with Chapter 9, the Judicial Branch. In Chapter 9, the Judicial Branch, we talk about our third created institution in the Constitution. In Article 3, the Judicial Branch was created, and it was created as an independent branch of government for the basic reason of dispensing justice. When it was first created, the judicial branch was not considered important. It was not even really thought about. In fact, the judicial branch at the time, no one wanted to be a member of the Supreme Court. Everybody shied away until Justice Marshall got onto the court. And when Justice Marshall got on the court, with his long tenure in office, gained its respect. So without any further ado, let's go with Chapter 9, the Judicial Branch. As normal, I will use the PowerPoint slides to go through. Many of you know who have been viewing this know that I hate PowerPoint slides, because I would like to be more in front of a classroom, explaining it in more detail with the knowledge that I have, but I will use the slides as a complement to, or an outline to go over the general details that this book has, and we will touch as many concepts as possible. Now, Chapter 9, the Judicial Branch. All right, Chapter 9, the Judiciary. Our learning objectives is to describe the constitutional foundations of the federal judiciary and judicial review, describe the structure of the federal judiciary, outline the criteria for nominating and the process of approving federal judges and Supreme Court judges, and outline the process by which the Supreme Court makes decisions and factors that influence judicial decision making. The roots of judiciary: the Supreme Court's jurisdiction, the Judiciary Act of 1789, and the creation of the federal judicial system, the Marshall Court, and Marbury versus Madison, 1803, in judicial review. Original jurisdiction: the Supreme Court's jurisdiction. Original jurisdiction lies in the federal system where the trial court hears the case. So say like in the judicial district of Oklahoma City, any federal charges or any federal cases that is heard within the judicial district of Oklahoma City, which encompasses mostly Southwest and Northwest Oklahoma and Central Oklahoma, falls in that court, and that is the original jurisdiction. Any other jurisdiction in Oklahoma is in Tulsa, and which is the trial court in Tulsa, which hears all cases eastern Oklahoma. But let's just say if the case involves any conflict between two state governments, if it does, the original jurisdiction between those two state governments, as it says in Article 3 of the Constitution, belongs to the U.S. Supreme Court. But let's say if your criminal case or if you're a civil case, you disagree with the decision and you appeal. Well, that will go to the appellate jurisdiction, and it will go to the appellate division court. And here in Oklahoma, I believe we are in District 13, and that goes to Denver, Colorado. And that's where the appellate court judges will hear the case again based upon the evidence and the law only. Now, there may be, if the court decides to hear any testimony, they will allow that. But mostly it will not be like the trial court. It will be based upon the evidence that is provided and strictly the law. If for some reason that the case, what decision comes by the appellate court does not fly, it goes to the U.S. Supreme Court if the U.S. Supreme Court approves it. So let's move on and let's talk about the Judiciary Act of 1789. The Judiciary Act of 1789, and it says here it created a three-tier court structure. Federal district courts, circuit courts, and the Supreme Court. Really, the Judiciary Act of 1789 really kind of created some circuit courts. And there were federal courts, yes, indeed. But the circuit courts were very few. And the reason why they called them circuit courts, that members of the U.S. Supreme Court actually ran a circuit in which they have to go to that court and sit and listen to cases that were up for appeal. And then, of course, if the judge renders an appeal, renders a decision that a party didn't agree with, they would, of course, try to appeal to the U.S. Supreme Court, and the U.S. Supreme Court will either hear the case or not. Now, one of the reasons why it was so rocky at the beginning of the U.S. judicial system is simply that no one thought much of it. It was not considered a prestigious position to be a member of the U.S. Supreme Court. Famous lawyers and other judges throughout the country, when they were asked by President Washington to sit on the U.S. Supreme Court, once they got there and noticed that there were any facilities or offices or anything of respect for the court, many of them just quit, tenured their resignation, and just went on. Justice John Marshall was asked 3 times to sit on the court, and eventually in 1801 he agreed. His tenure lasted from 1801 to 1835, and he established the respect of the U.S. Supreme Court as we know it today. And during his tenure, he oversaw some of the major court decisions that not only established the respect of this third institution, the U.S. Supreme Court, but firmly adjudicated over cases that establishes the supremacy of the federal government, as well as established the demarcation line between state and local government. In McCullen versus Maryland, which I hate that this is backwards. We need to redo this. In Marbury versus Madison, in which a case in which President Madison was when he received from John Adams last-minute judge appointments to the different courts and expanded on a law to add more judicial seats. Marbury was one of the judges involved who wanted to receive one of these judicial seats. And when President Madison decided to eliminate these judicial seats after the Federalist Congress had approved them, Marbury took the case to court, eventually aligned it to the Supreme Court and the Marshall Court. And remember, every court is named after the Chief Justice that is presiding at the time, came back and established that the law that actually created this issue in the first place as unconstitutional. And even more, that in the Federalist Papers, it's implied in the Constitution that the court itself actually has the right of judicial review, which means that the court has every right to look back on any legislative law or any court case and determine the validity of that case when it comes to the Constitution. If the court decides, and when I use the word court, I'm talking about the Supreme Court. If the court decides that a legislative law, means a law that was approved through Congress, signed by the president, is against the Constitution, the court has every right to declare it unconstitutional. Any decision by a lower court, be it a lower federal court or state court, that is against the Constitution or with the Constitution, the court has the right to decide if that judgment is constitutional or not. So Marbury versus Madison gave the Supreme Court, gave the judicial branch, gave Article 3 its teeth, even though the teeth of Article 3 was implied, especially within the Federalist Papers. Marbury versus Madison made it applicable in open court, which stands still today. In McCollum versus Maryland, one of the greatest decisions by John Marshall, when Maryland tried to tax the Bank of the United States, which was an establishment of this the United States government, McCollum, who was in charge of Bank of the United States, filed suit. Of course, state of Maryland agreed with the state of Maryland, but it went to the U.S. Supreme Court. The U.S. Supreme Court under John Marshall said in 1819 that the federal government is, under the Supremacy Clause of the Constitution, is the highest law in the land. The Constitution is the highest law in the land. And that the federal government has overall sovereignty, that no state has sovereignty over the federal government, nor does the federal government has claim can violate the sovereignty of a state, so that no state cannot tax any federal property. Federal property cannot tax state. So it set the pure demarcation of McCollum versus Maryland, that the Supreme Court, the federal government, is the supreme law in the land. State court as well has its own sovereignty, but it can never override the federal court. Never could override federal authority. Now, why is John Marshall important to the development of judicial authority? With Marbury versus Madison, it was everything with that case. If Marbury versus Madison did not come through, the court pretty much would be impotent today. John Marshall's decision, John Marshall's enlightened view of what independent court should be, made the third institution under Article 3 that we have today relevant. What is the constitutional basis of a judicial review? We just went over that. Now the federal court system. You have the district courts, the Court of Appeals, and the Supreme Court. Now here's how this is set out. You have the basic district court, and this is usually mostly within a state. And the district court, like I said, here in Oklahoma, is the district court in Oklahoma City, district court in Tulsa. And that is the original jurisdiction of most cases per term. So that is the lowest court in the federal system. The appellate court, on the other hand, has no original jurisdiction. It's just simply appealed to the appellate court so they can hear the case. And if a case is disagreed with the decision of the U.S. Appeal Court, it goes to the U.S. Supreme Court. Now, if you are charged with a state charge, be it a criminal charge or you're being sued civilly, you can handle it in the state court. If for some reason that the lower court in the state did not make the right decision or you disagree with it, you can go to the appellate courts of the state. In the state of Oklahoma it is either the Oklahoma Criminal Appeals Court or the Oklahoma Civil Appeals Court. That's how it's done in the state of Oklahoma. Now, from there, it goes to the Oklahoma Supreme Court when it's a civil case. And if the Oklahoma Supreme Court doesn't agree with it, you can appeal to the U.S. Supreme Court. But if for some reason your criminal case does not do well in the Oklahoma Criminal Court of Appeals, that you can appeal that case to the U.S. Supreme Court. Oklahoma's a little jinky on how it does. So that's basically how Oklahoma works. The district court. Each state has at least one. Its original jurisdiction, and the U.S. attorneys work the case in the U.S. District Court. The Court of Appeals, 11 courts of appeals. A 12th is restricted to federal registry commissions and 13th to patents. So I believe I have the number wrong that we were in the 13th district. I need to check to actually find out, because I remember when I started my career, we had the 13th district, but obviously it changed and I didn't look it up. The number of judges vary depending on workload and complexity, and does not have the original jurisdiction. Here are the boundaries. So we are in this area here, and we are in Circuit 10. So if a case happens here in a federal court, and see, look at this, guys. And this is how I'm off. I knew about Oklahoma City District Court, but there's a district court in Tulsa. But looky here, we have another district court here in the state of Oklahoma. And see, that means I need to keep up. So that's on me. But right here, we are in district or Circuit 10. So our appeals court is here in Denver. The Supreme Court of the United States is the final interpreter of the Constitution. Its members are 8 associate judge and 1 chief justice, and the size of the court is set by Congress. This is my opinion. I believe a constitutional amendment needs to be placed to not only set a permanent number of Supreme Court judges, but also to set minimum qualifications for Supreme Court justice. And the reason why is for this, because depending on the political party who's in the White House and Congress, really nothing can be done politically to threaten the court's independence, with the exception of taking funding away from clerks or basic operations, or adding more justice on the Supreme Court that just simply reflect the philosophy of the party in charge. In order to protect the U.S. Supreme Court, in order to maintain the independence of the court, I believe a constitutional amendment is needed to maintain a specific number and basic qualifications. Precedent. Are rules binding throughout the nation, or stare decisis, which means on its face, let the decision stand? So here's a question. I mean, here's an example. Let the decision stand. Stare decisis. Plessy versus Ferguson is when in 1896 the Supreme Court says separate but equal facilities are constitution. So stare decisis, let the decision stand, meant that any operation of separate but equal facilities for blacks and for minorities and whites was considered constitutional. And if that was challenged at any time, the precedent, looking upon the evidence of what was going on in the state, that will remain precedent. But of course, we knew in 1954, Brown versus the Board of Education at Topeka, Kansas, in which the court reviewed the Plessy versus Ferguson decision of 1896 And it discovered that separate but equal facilities were not possible, and considered it very unconstitutional because not only the Constitution did not explicitly say it, but does not imply separate or equal facilities. And that's why on its the decision did not stand, but a new decision replaced it. And the Brown versus the Board of Education case to this day is where the decision stands when it comes to any form of segregation and eventually discrimination. How the federal court judges are selected, who are federal judges, nomination criteria, and the confirmation process. Background. Generally, most judges had held other judicial appointments before. Even though the Constitution does not give any explicit directive on who can be a Supreme Court or appellate or even a district court judge, most judges either had a law career or had other judicial positions before. They are usually active in politics. They either support one side or other or both sides. And the good thing about it, the diversification of eligible Supreme Court justices and federal justices is growing. The look of the justices are beginning to look more like America as a whole. The nomination criteria. Now, when a Supreme Court justice or a district court justice or an appellate court justice is chosen, the president who nominates them, who appoints them, usually goes through a criteria. Their course are investigated by the FBI to make sure there is nothing hinky going on. But a list of judges are made due to their experience, their ideology or policy preferences. So if it comes close to the president that nominates them, that's a plus. Any rewards that they won in their field, the pursuit of political support. What kind of political support did this nomination or this person give to me as the president? If they're religious or not, and sometimes their race, ethnicity, and gender. So this all comes into play when nominating a Supreme Court justice, appellate court justice, or district court justice. And then after the president has nominated the person who they want to sit on the federal courts, then the nomination goes to the Senate for final approval as the Constitution spells out. The confirmation process is, again, the justice or the person up for the nomination is investigated again by Congress. Many interest groups lobby and support for that justice or against that justice. And the Senate committee hearings on the Senate subcommittee hearings on if this justice should be supported or should be voted down will be held. So that will give the person who is nominated for that judgeship to speak in front of the Senate in support of their nomination, but that also gives other people who want to criticize or who either want to support or not support that person's nomination to be heard as well. Eventually, if that person is approved in committee, it goes to the floor for another hearing and then a vote. And if the Senate votes to nominate that person is nominated, sworn in, becomes a district court judge, appellate court judge, or Supreme Court judge. And that's how the process rolls. Now, how the Supreme Court makes decisions. Well, the Supreme Court either decides to hear a case or not. How does a case survive the process? Hearing, deciding the case, and factors influencing judicial decisions. Deciding to hear a case. Writ centari and the rule of four. A writ centari is simply an introduction to hear a case before the U.S. Supreme Court. Basically, the appellate courts have said, hey, that we've rendered this decision. One of the people involved in that decision has disagreed with that decision and has decided to appeal before the Supreme Court. The writ of certiorari is submitted, and then 4 Supreme Court justices review this case. Well, not just 4, but several. And if 4 Supreme Court justice says if there is a federal question, a constitutional question that is involved and must be heard, it will be approved, and all the case file, all the evidence, everything of the entire history of that case is transferred to the Supreme Court. Now, during this decision, is one of the things it doesn't say, any other similar cases that are currently out there are usually combined at this time. Now, here's something a lot of people don't know. The role of the clerks. They make the first pass through the petitions. Clerks, who are usually the best from law schools around the country, in which these judges do hire them to help them, they look over the cases and determine if a case has either merit or merit enough so a Supreme Court justice can see it or not. They're this filter, they're this gatekeeper. And let's just look, most of the cases that come up to the Supreme Court for consideration, pretty much a good 90% of them are rejected. Only 10% actually filter through. Now, how a case survived the process is, it depends on the case itself. If it's a case by the federal the Solicitor General of the federal government, basically the federal government's attorney, it usually is looked upon, and if a case has merit, it is taken into consideration as being accepted. If there was conflicts among similar cases between different courts of appeals, let's just say like the McGirt ruling in the state of Oklahoma, the 10th Circuit of Appeals disagree, but something similar in the 2nd Circuit was before the Court of Appeals at the time, and decisions between both conflicted. The federal government brought those cases together. The Supreme Court brought those cases together, combined them into one as the McGirt case, and eventually decided that yes, Oklahoma had it wrong, the other appellate district had it correct, and that the reservations for Native Americans weren't destroyed, and most states who ignored reservations, who ignore Native territory, have broken law, and most laws that says that states can simply ignore those things are considered constitutional. But also, like the McGirt case, there's something else called amicus curiae briefs. Amicus curiae briefs are called friend of the court briefs. And these are briefs done by private citizens or individual groups that bring forth additional evidence or information that may not be provided in the court case, so that not only the clerks but the Supreme Court justices can look over for additional information. This is the only way that special interest groups of any sort, be it different family groups, regular citizens groups, corporate groups, or even political groups, can actually lobby the Supreme Court by simply submitting a brief in support or against a specific case, and allowing the Supreme Court to weigh that evidence. Hearing and deciding a case. The Supreme Court may look over the case and just decide, maybe we can just simply decide it on our own. But at other times, the Supreme Court may want to hear oral arguments. They want to hear from the lawyers who are involved in the case and hear their arguments. Each lawyer has 30 minutes to speak on behalf of their case. And then the Supreme Court justices start asking them questions. Individual justices ask them questions about certain thoughts that they have or knowledge that the Supreme Court justices have of the case, which will help them decide the case. Then after it's over, they go into a conference. And they have a conference to decide on how they're going to vote for a case, either for or against. But one of the things that happens in this conference, and that this outline does not really say, is that the Supreme Court justices may get into this conference, start discussing this case, looking at the available information from not only the case itself, but for the amicus curiae briefs, and may ask for another set of oral arguments. Like in the McGirt case, there were additional hearings to hear oral arguments again, because the McGirt case came out or was decided in June of 2020. All right, but understand, oral arguments, the first oral arguments for the McGirt case actually were heard in fall of 2018. And everyone suspected that by June 2019, that the decision for the McGirt case would come out. And actually what happened in June of 2019, the Supreme Court declared that they wanted to hear the case again. And later in the fall of 2019, they heard the case again, received more information, looked into it more, and by June 2020, came down with the decision that they did for the McGirt case. Now, when the Supreme Court decides on a case, they write opinions. When the Supreme Court was started earlier, each individual judge wrote an opinion in support or against a decision in the court. But later, after the Marshall Court, usually the Chief Justice or whoever the Chief Justice appoints to write the decision was the one who write the winning decision or for the entire court, based on the evidence and the overall deliberations. At times, you may have individual justices that may say, hey, you know what? I understand the decision. I kind of disagree with it. I understand the decision and I agree with it, but I don't necessarily agree with the logic that was followed, and this is why. It's usually a concurrent opinion, and justices are free to do that. But then there are dissenting opinions. And in dissenting opinions, and one of the reasons why I love Thurgood Marshall, and it's something that I thoroughly miss out of Supreme Court justice, many Supreme Court justices today, especially Clarence Thomas, is that Clarence Thomas has this theory of simply, when he writes an opinion, be it consenting or concurring, he wants to keep it simple so that a person with an 8th grade education can understand it. I understand that. However, it doesn't come across as very well thought out. You can write an opinion that an 8th grader can understand and needs to be thought out. And he has written very few. But just as Thurgood Marshall, on the other hand, in his concurrent opinions and his dissenting opinions, and when he was writing the majority opinions, in many ways, was very thorough. Yes, there were legalese involved, but you could clearly see what Justice Marshall was saying. And he wanted to make sure that if he was against a certain opinion, that there will be a well thought out reason why, so it can be considered later. Factors influence judicial decisions, like judicial philosophy and ideology and public opinion. Let's see here. Well, let me go back to that. Thought it was going to be more than that, but I guess not. All right, let's go back to judicial philosophy. Judicial philosophy and ideology goes a long ways on how judges decide a case. Judicial restraint means that not necessarily that a judge, when making a decision, will go too far away from the case that has already been decided, stare decisis, or will be more tempered in its decision, especially if law is going to be changed. It will be applied strictly towards the law when a decision in the affirmative or in the negative is done by a judicial restrainer. A judicial activism looks at the Constitution in a little different way. That person looks at the Constitution as an evolving thing. So does judicial restrainer. But the judicial activist person looks at it more in how the individual culture, the individual ideology and philosophy of the country as a whole has changed, and will base a lot of decisions not necessarily on previous law, but the changing and understanding and the meaning of the law today. And the strict constructionalist is a person that goes by the strict interpretation and construction of the Constitution. There is very little room for movement there. Now, public opinion. The court does weigh the public opinion on its decision. It wonders how the government will be able to govern sometimes. The court influences more public opinion than anything. One of the reasons Roe v. Wade influences a big understanding of how public opinion is today. Because of that one case, a good chunk of the United States has split. And it's split on something that is totally different. Even though Roe v. Wade gave a woman a right to an abortion, but the look of it by the public was totally different than the actual judicial decision that was delivered, because one side saw it as a right to just kill babies. The other side saw it as women being freed from male domination. And in reality, the decision of Roe v. Wade was neither to allow women to just kill babies ad hoc or to free women from the slavery of male masculinity, but it just simply upheld its understanding in Griswold versus Connecticut of privacy in your own home, and that a woman has a right in her own home to decide what she wants to do with her body. It's her private act, and that's it. So in order to settle this case, these two groups, which is the major divide in our country today, must understand and figure out how to preserve the privacy of the woman and the understanding and interpretation of the law. Implementing court decisions, judicial implementation, how judicial decisions are translated into public policies. Well, really, any judicial decision is simply done by the executive branch or the president or Congress to follow, or for the states to follow. Like one decision made in 1962, in which the Supreme Court says that it is illegal for the federal government to recognize any religion, which is uh, uh, First Amendment, the Establishment Clause of the First Amendment, that prayer in schools is unconstitutional. See, a lot of people just only read that part. It says prayer in public schools. Any place where there's federal money sponsoring that school makes it unconstitutional because the federal government, the public schools host everyone. Doesn't say that it eliminates it in private schools. And many communities today, many school systems today ignore that ruling and continue on with a public Christian prayer in school. And in reality, that school district should not implement that. There is nothing wrong for a moment of silence. There's nothing wrong for giving a person a moment to think who they believe as a creator. And if you don't believe, go ahead and just enjoy the moment. There's nothing wrong with saying. But in such defiance as many Americans are, they want to interpret it one way. And that's incorrect. We have to take the emotion out of these things. That's the fault of not critically thinking. Remember, critical thinking is to look at all the information and to make an informed decision without the emotion. And when you look at these judicial decisions, they're based upon law and the interpretation of the Constitution. Take the emotions out. That's it on that. And that's Chapter 9 of the Judiciary. Yes, I expressed some of my opinions in this on how the judicial branch should have 9 permanent members. There should be a constitutional amendment established. I know I expressed that opinion, and I know that a lot of people don't believe with that opinion. That's understandable. That's fine. But judicial decisions are straightforward, more straightforward than anything. Now, I will be the first one to say, like in Dred Scott, Plessy versus Ferguson, and many other cases, the judicial branch has fallen on its face, has simply bowed down to the culture and the nativism of that time. I would say even with the level of conservatism on the bench today, it is so much better and it's more reflected of society today and the diversity of not only the federal court system, but also the U.S. Supreme Court helps with that. But one of the things, the major problem we have when it comes to judicial decisions is not necessarily the court itself, it's politicians and individual citizens who don't critically think and look at the decisions for themselves. Everyone wants to get rid of something that they don't necessarily like. And at times, I'm one of those people. But when you look deeply on the decision and what was made, you'll notice that the Supreme Court has done everything possible to protect your rights under the Constitution. So when you look at a court or look at a court decision and you hear from everyone else either making a stink about it or celebrating about it, look into it yourself and determine, why did the court make this decision? In their opinions, they explicitly write why they make that decision. And then make your decision from there, if it was a good decision or bad. If it was a bad decision, guess what? You as an ordinary citizen, if something like this comes up, you can file a lawsuit. You can challenge it legally. Don't worry about the money, because if there's someone for or against that ruling, there will be money out there to support your cause and take it all the way to the Supreme Court. For marginalized communities, for this message right here, I'm talking about Black, Hispanic, Native American, Asian, other communities, and even poor whites. If you feel that your constitutional rights are being violated on the local, state, or federal level, challenge it. Always challenge it. Get yourself a lawyer and challenge it. If not, write up at least a 2-paragraph document and submit it as a lawsuit in federal court, and read the basic rules of civil procedure that is listed online and get your lawsuit in. Do not let 2 years pass by after something has happened. Protect yourself and fight and fight. The worst thing that could happen through it all is that the court will come down against you. At least you were heard and your name and your complaint is in the records of time. Until next time, which is chapter 10, remember to do your best you can, think critically. God bless you all, and I will see you later.